Zero in Washington.
I find everyone's very funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiffs.
Battle, please unmute and state your name.
Anise Battle, appearance especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Right from the jump, Anise Battle begins her questioning like she's auditioning for Law and Order, Sovereign Citizen Unit. Instead of addressing the unpaid rent issue, she fixates on whether she ever waived her rights. Now, here's the thing. Signing a lease is a legal agreement. By doing so, you automatically agree to its terms. The opposing counsel is visibly confused, and Judge Washington tries to redirect her, but battles using language she doesn't understand. The first red flag that we're in for a long, chaotic hearing.
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission.
Here's where the real comedy begins. Battle claims she rescinded her lease, as if she could just declare it void like a magic spell. But legally, rescission doesn't work that way. You can't just unilaterally cancel a contract because you feel like it. The judge and the plaintiff's lawyer make it crystal clear. This case is about unpaid rent, not contract cancellation. Yet Battle keeps pushing her common law theories, showing exactly why sovereign citizen arguments fail every single time. You can almost hear the judge's patience cracking with every objection.
It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law and landlord-tenant acts.
That's not, we're not under common law anymore, ma'am.
And here's the viral moment everyone talks about. Battle insists her rights come from the Magna Carta, a 13th century English document, as if medieval British law still governs Michigan housing disputes. Judge Washington's response is pure gold. We're not under common law anymore, ma'am. It's professional, firm, and loaded with disbelief. This is the moment viewers realize this isn't a legal argument. It's delusion wrapped in outdated terminology. The courtroom's silence speaks volumes. Even the judge's restraint deserves an award.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object.
This next exchange is a masterclass in how not to use Google as your legal education. Battle confuses a notice to quit with a demand for possession. These terms matter. One applies to ending a tenancy, the other to evictions for unpaid rent. The attorney politely explains this while the judge nods in agreement. But Battle insists she's right, quoting the wrong Michigan statute. MCL 657.16 instead of 600.57.6. It's a small mix-up that reveals a bigger issue. She's parroting phrases she doesn't understand. At this point, the judge isn't just fighting nonsense. She's fighting Wikipedia lawyering.
I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry.
What was the statute that you cited?
Read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next. Is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service. And I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes she cites them correctly.
Okay, that's fine. I didn't cite an exact statute.
Notice how Battle keeps returning to the same rejected idea, that she somehow unsigned the lease. The judge reminds her yet again that her argument has already been overruled, twice. Battle doesn't care. She accuses the court of bias and doubles down with even wilder logic. Then comes one of the judge's best lines. If it walks like a duck and talks like a duck, you know the rest. That line wasn't just humor, it was legal reality. This case stopped being about rent a long time ago. It's now about maintaining sanity in the face of stubborn delusion.
All right, well, everybody, so
You,
let I make my ruling.
let's just, okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
Okay,
is
answer that question.
not on the disposition. And just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no
It's
such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most.
You'd think after multiple corrections, Battle might ease up, but no. She now brings HUD into it, claiming the landlord violated federal grievance procedures. It's completely irrelevant to this state-level rent case. The opposing counsel calmly objects, explaining that HUD rules only apply if the tenant actually receives HUD assistance, which she doesn't. But Battle's logic? If you accept HUD tenants, you're under federal law. That's like saying if you serve someone a salad, you're governed by farm regulations. The judge's face says it all, disbelief mixed with exhaustion.
From HUD, which is through Section 8 vouchers or regular vouchers. You get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Miss Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's
Got a question for
Dawn, my plaintiff.
her. No, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If
Not
I
a-
cannot have, this is not a fair hearing. And again,
No,
this is why
not, you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
Please move
all
on.
of this is not right.
I'm telling you
And
now
attorney
that I'm going to be filing criminal proceedings against you for all these frivolous things.
And here's the turning point. Judge Washington finally looks up the law herself to verify the citation Battle keeps mangling. Turns out the plaintiff's attorney was 100% correct. Battle's quote doesn't even exist in that form. The courtroom air shifts. It's quiet, awkward, and brutal. You can practically feel the embarrassment. But what's impressive here is how the judge still manages to stay composed, using logic and patience instead of sarcasm. She's seen this before, and knows the only way to end a sovereign citizen spiral is with calm, precise facts.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
Battle, if
That
you're
would
not
constitute
going
as
to
the
ask
same
appropriate
type of
questions, then I'm
law.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silent.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshal. So I don't know. I'm stuck on what to do. The integrity of the court is
something
questioned.
wrong with you. I don't know what that is, but you should seek some mental help, because something's
sorry?
wrong with you. You have
You
a
said
mental
what?
You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right. I have
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today, because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation, and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action, and I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3,609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection.
So what did we just witness? A simple landlord-tenant dispute turned into a full-blown conspiracy of pseudo-legal arguments, misquoted laws, and defiance of reality. Judge Washington handled it with surgical precision, firm, fair, and unshakably professional. This case is the perfect example of why courtroom education matters. You can't win arguments with fantasy law. You win with facts, evidence, and respect for the process. If you found this case as unbelievable as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. You won't want to miss what happens next in Judge Washington's courtroom.